Well, I don't know about the rest of you, but I'm tired of people who know nothing about the Constitution making laws that don't go along with it. Here's a nitwit who should know better, but he doesn't. So he's going to increase background checks by cracking down on firearm dealers who violate the law. Latest attempt by the administration to reduce gun violence. Well, he's not doing nothing to stop all the car accidents. There are a hell of a lot more of them. But what the nitwit fails to even think about is he's putting himself in a bad position. I'm going to zoom in here, people. I want you to see this. Section 242 of Title 18 makes it a crime for a person acting under the color of any law, which he's doing, to willfully deprive a person of a right or a privilege protected by the Constitution of the United States. Under the color of law includes acts not only done by federal, state, or local officials within their lawful authority, but also acts done beyond the bounds of that official lawful authority. If the acts are done within the official is purporting to or pretending to act in the performance of his or her duties, that person can, like police officers, prison guards, and other law enforcement, as well as judges, care providers in public health facilities, and others who are acting as public officials, it's not necessary that the crime be motivated towards race, color, religion, sex, or anything else like that. This offense is punishable by a range of imprisonments up to life term or the death penalty, depending on the circumstances of the crime and the resulting injuries, if any. So breaking the law by creating a law that he didn't pass, that Congress didn't pass, excuse me. Let me get this down here. Can't pass a law under the color law. Bill Clinton was known for that. Yep, executive privileges. Well, let's get to something else. Here, people. We went through this before. We're going to go through it again because this is your preamble to the Bill of Rights. They would not pass the Constitution until these amendments were put into place to keep the government off of our backs. It says, the Congress of the United States being held at the city of New York on Wednesday the 4th of March, 1789. So 1789, they put this in here. And it wasn't passed until 1791. The conventions of a number of the states having at the time of adopting the Constitution expressed a desire in order to prevent misconstruction or abuse of its powers that further declaratory and restrictive clauses should be added. They wanted to make sure there would be no more problems. None. And declaratory means it's explanatory. It's designed to fix which was uncertain or doubtful. So it says here, the convention of a number of the states having at the time of adopting the Constitution expressed a desire in order to prevent misconstruction or abuse of its powers that further declaratory and restrictive clauses should be added so it extends the ground of confidence in our government. And one of the things it has here is we have the Second Amendment. It says, shall not be infringed. Oh, I'll tell you what, people, it's just unreal. Quarterly anywhere, or there's nowhere in the Constitution where Congress was granted authority to abridge, restrict, or infringe in any fashion whatsoever guns or ammunition. Thus, all restrictive laws made by Congress, all regulations made by the Bureau of Alcohol, Tobacco, and Firearms are unconstitutional as they are outside the scope of powers granted to Congress and to the executive branch by our Constitution. Restrictions of arms and ammunition is not one of the enumerated powers delegated to Congress or to the executive branch. Now you're going to have people up here say, oh, well, we had constitutional lawyers check this out. Well, let me tell you about constitutional lawyers. They went to school. They didn't study the Constitution. What they did, they studied the writings and opinions of other judges, thus making that judge the law and not the Constitution itself. I'll say that again. They went to school. They didn't study the Constitution. They only studied what other judges said about the Constitution, what their opinions were, thus making that judge the law and not the Constitution itself. That's why you need the Supreme Court to step up and do away with all these unjust laws that some of their members before had let slide by. Like the 1934 law, all those laws are null and void because they're outside the scope of powers granted to the Congress. You cannot show me any place in there in the enumerated powers where Congress was granted that gift. Now, some numbnuts of a lawyer, long time ago, Supreme Court Justice, said, well, you know, it means whatever the Congress says it means, and that's not right. He's not going by the Constitution. Constitution means what the people say it means. Where rights are secured by the Constitution, there can be no rulemaking or legislation which would arbitrate them. Non-constitutional law is no law. It confers no rights, it imposes no duties, affords no protection. It creates no office. The general rule that an unconstitutional statute, although having the form and name of law, is in reality no law but wholly void and ineffective for any purpose, since unconstitutionally dates from the time of its enactment and not merely from the date of the decision so branding it. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. All laws that are repugnant to the Constitution are null and void. Marbury versus Madison. In the U.S. Constitution is the supreme law of the land, and any statute to be valid must be an agreement. It is impossible for a law that violates the Constitution to be valid. The people. Now, part of this came from this lady's blog, Understanding the Constitution. I want to read something else here. The Second Amendment to the United States Constitution ratifies and preserves for every citizen the right to keep and bear arms, and, moreover, that Congress nor any instrument of the federal government can infringe upon that right because they are constitutionally barred from doing so. You got the poor people out here having to pay big bucks to lawyers and stuff to protect their rights when our Constitution says that our government is supposed to protect our rights, and it's not happening. I think the government should reimburse us for all of our turmoil. When any person that comes forth with a law like this is not a loyal American. He's a communist imposter. All right, well, he's an American imposter, but he's Russian or communist. Excuse me, I got a cat in the way. Yes, baby girl, I know you don't feel good. But anyway, that's what's going on, people. Know your Constitution. stand up for it. Constitution of the United States. The only keepers of it are the people. Something else I'll show you here. Besides that calendar that defend your, I better unzoom this. This thing's zoomed up too much. Defend your Constitution before it's too weak to defend you. Now hopefully our Supreme Court will get on this right away and put things in their proper place. All these laws are unjust. It's like that domestic violence law. When you pass a law, it's to take effect after that date. And they went and made it retroactive and went all the way back to Adam and Eve. They can't do that. It's unconstitutional. It doesn't work that way. All of them laws they make, like I said, are unconstitutional because they don't. It's beyond the scope of powers that were granted to the Congress by the Constitution. They're all null and void. Our Constitution says so. Okay, thanks for watching, people. Stand up for your rights. Know your rights. Don't let these people trample them. You've gone too far already. Thanks for watching.